the SulmeyerKupetz webinar. My name is Asa Hami, and with me is Claire Wu. We are both attorneys at SulmeyerKupetz. As I'm sure most of you know, SulmeyerKupetz is a bankruptcy and financial restructuring firm in downtown Los Angeles. We put on these complimentary webinars on a fairly regular basis on a wide variety of bankruptcy-related topics. As the title to this webinar indicates, in today's webinar, we're going to walk through the life of a commercial Chapter 11 debtor and the different stages and events of that process. Now, before we get into the heart of the webinar, I think it's important to explain why we chose this topic and why we thought it was important. The first thing to note is that Chapter 11 is a very specialized area of law. It is a complex process and definitely requires competent bankruptcy counsel. I sometimes see Chapter 11 cases being filed by attorneys that I know don't have the requisite experience to take the client through the Chapter 11 process, and the case ends up failing, either having a trustee appointed or being converted to a Chapter 7 liquidation or getting dismissed. In addition, over the years of practice, when I'm on the other side, not representing the debtor in the case, I could tell, you could just sense that the debtor probably did not fully understand what it was getting into when it filed bankruptcy. And I think debtors or potential debtors are unaware of the process, at least from the outset. And unfortunately, they often don't get or understand the full picture of what happens in a Chapter 11 case before they make the decision to file the case. I just don't think they fully appreciate either the complexity of the process, the different parties involved, the extent of all the requirements of a Chapter 11 debtor, the impact of being in a bankruptcy case, that the impact that it may have on the company's operations, the cost of going through the Chapter 11, and also the time it takes to go from start to finish. So in light of all that, we put this webinar together to provide more of a kind of a bankruptcy 101 course, mainly for non-bankruptcy practitioners and for companies that may be contemplating Chapter 11, to identify the different stages of a Chapter 11 case, from the period immediately before filing the case through and including the period immediately following confirmation of the Chapter 11 plan. Now, there is a lot of information and a lot to cover, and we'll try to keep it within 1 hour, but as a result, we may need to move quickly through some of the material to do so. However, if at any point you have a question, or even after the webinar you have a question, the best way is to just contact us directly, and we'll address the questions at that point. So with that, let's begin with an overview of the different stages of a Chapter 11 debtor's life. So first, at the most basic level, there are 3 stages in every Chapter 11 case. You have the pre-petition period, the pre-bankruptcy period. Then you have the post-petition period. Then we've broken this up in this webinar into kind of the early, middle, and late stages. And then you have the post-confirmation period. In this webinar, we'll discuss each of these periods, and as each period really could occupy a full webinar of its own, we're only going to provide a brief overview of each period and the primary events that occur during that period. And now, something to note is that the Chapter 11 case is not necessarily linear. So now, obviously, there are certain things that have to come before others. Obviously, the case has to be filed, so you're in the pre-petition period before you get to the post-petition period. But within each period, events may occur at different points in the case, and not necessarily in the order we presented here. It really just depends on the type of business involved, the issues that the particular business is facing, and sometimes the conduct of other parties in the case. So while we talk about the early, middle, and late phases of for example, the post-petition phase, and the events that occur, keep in mind that obviously things could happen at different points and in a different order than we present it here, depending on the nature of the case and the issues at hand. So there's nothing hard and fast in terms of the particular order that events may occur. On a final note, Chapter 11 could be filed by an individual or a company. This webinar focuses on a non-individual case, and also a bankruptcy case could be a voluntary case or an involuntary case. Now, this webinar focuses on a voluntary case. If you are interested in learning more about involuntary cases, I actually did a webinar a few years ago, and I published an article in the LA Lawyer specifically about involuntary bankruptcy cases. And on the prior slide was a link to the webinar, and on this current slide is a link to the article. And I think my understanding is that after this webinar, you'll be emailed a PDF version of this PowerPoint, and through that PDF, you'll be able to click on these particular links to access the prior webinars and the article. Okay, so with that, let's get into the different periods of the case. So the first stage, obviously, is the pre-bankruptcy stage before the company actually files bankruptcy. And in this stage, we're going to discuss 4 general topics. So first, we'll identify the key parties. Second, we'll discuss the planning period, which involves both planning for the bankruptcy filing as well as consideration of other options, which is referred to as the contingency planning. Third, we'll talk about how to present the Chapter 11 case, and we'll see that there are 3 usual ways to do so, including what's called a free-fall case, a prearranged case, or a prepackaged case. And finally, we'll discuss actually preparing for the Chapter 11 filing. So we begin with identifying the key parties. Now, the need to understand who are the key parties spans both the pre-petition and post-petition phases. However, we address this now rather than later because identifying the key parties early and before actually filing the case is important for the planning for the bankruptcy filing. The first group of key parties we identified are the company's secured creditors. Now, those are creditors obviously with liens against the debtor's assets, usually a bank that provided some kind of financing, a line of credit that the company used or was using to fund operations. It is important to meet with the lender before filing the case because, as we'll see later in this webinar, the company will need to use cash collateral post-petition to operate. And to do so, the company will either need to get the secured creditor's consent or court approval, and it would be best, if it's appropriate, to meet with the lender before the case is filed to get their consent to use cash collateral and to work out the terms of that consent and cash collateral usage before the case is filed. And also, the company may need more financing from this particular lender, and it's better to work out the terms of the post-petition financing before the case is filed, especially if the financing is going to be needed immediately after the case is filed. The next group of key parties we identified are the company's critical vendors, and these are vendors that a company cannot continue operating without their continued receipt of their goods or their services. The company will need their goods or services post-bankruptcy and may need to incentivize these critical vendors to continue doing business with them post-filing. One way to do this is to offer to pay the critical vendors their pre-petition claims post-petition, post-filing. However, to do so, the company will need court authority because the company, once in bankruptcy, is not allowed to pay a pre-petition claim post-petition absent court approval. So it is a good idea to identify the critical vendors ahead of time to work out, or at least to try to work out, whatever the company may need to do to ensure that they continue doing business with the company post-filing, which may include seeking court authority to pay their pre-petition claims after the case is filed. The next key party we identified is the United States trustee. This is an arm of the Department of Justice charged with oversight of the bankruptcy system. It's considered the watchdog of the case. The U.S. trustee is usually active at the start of the case, but then kind of retreats into the woodwork at some point later, especially when you have active creditor participation in the case. And depending on the size of the contemplated Chapter 11, it may be worthwhile to contact the U.S. trustee before the case is filed, just to give them a heads up that the case is going to be filed. The fourth key party we identified is the Official Committee of Unsecured Creditors. That is a committee that the U.S. trustee appoints after the case is filed. Usually consists of anywhere between 3 to 7, sometimes 9 of the largest general unsecured creditors. I actually was involved in a case that ended up having only one member on the committee, but that is very rare. The committee represents the interests of all general unsecured creditors and has standing to participate and be heard in all aspects of the case. And we'll get into more detail about this later, but we identify the committee here because the committee is an important contingency in the case. And then lastly, you have sort of this miscellaneous group. That depending on the type of the case, there could be other parties that play an important role in the case. So, for example, if you have a potential real estate bankruptcy case that operates many stores, retail stores across the country, then obviously they may have many landlords. So the landlords may play a significant role in the case as well. Now, whether or not, or to the extent to which a company reaches out to any of these parties or notifies them of the potential bankruptcy filing beforehand really depends on the specifics of the case and would need to be assessed on a case-by-case basis. All right, next let's move into the planning phase, and this is divided into two sections as we indicated in the overview. It's the bankruptcy planning, and then second, the non-bankruptcy planning, meaning the consideration of other options. So let's start with bankruptcy planning. The company, together with its bankruptcy counsel, will need to consider how they want or should present the Chapter 11 case. Now, by presenting the case, what we mean is really to what extent creditors are allowed to participate in the planning. And this breaks down into three general approaches. There is the free fall case, which is really kind of a surprise filing, and this involves no coordination of the timing of the filing of the case with the company's lenders or other creditors or key parties, even if those parties are aware that a filing is being contemplated. Then you have the prearranged case, and that entails having a consensus among lenders and other creditors that the case should be filed and when it should be filed, but you do not yet have an agreement on the terms and conditions of the filing or the terms of the plan and treatment of creditors in the case. And this approach usually contemplates negotiations and agreement on the Chapter 11 plan very soon after the filing. Lastly, you have the prepackaged or the pre-packed, as it's sometimes referred to, and that also entails a consensus among lenders and other parties that the case should be filed and when, but this time you actually have an agreement on terms and conditions of the plan and treatment of creditors before filing. And this approach usually results in the company being in the bank's case for the least amount of time as much of the work is front-loaded. As part of planning and preparing for the case, the bankruptcy counsel should conduct some due diligence on the company and should begin gathering information required for filing the case. And this should include establishing debtor contacts, meaning who at the company the counsel may contact to prepare for the filing, also obtaining names and contact information for important creditors that would require immediate notice of the filing, and also conducting lien and litigation searches on the company. Counsel and the company should use discretion in determining who may be contacted at the company, which employees and which creditors should be contacted. Sometimes only a limited group of the debtor's employees are aware of the anticipated filing. And it's important because unauthorized leaks of a potential filing could lead to adverse consequences. You could have vendors who may seize shipping goods. You could have competitors that may try to take away customers, take advantage of the situation. You could have employees that may lose morale and start searching for alternative employment. So you really should use discretion in terms of who should be contacted before the case is filed. The company and counsel also should start gathering all information and documents that will be required for filing the case and for various motions and other materials that will need to be filed and submitted early in the case. And I cannot stress enough that the earlier the company retains counsel and starts this process, the better. If you wait too long, it just results in a mad rush to get everything ready and to get the case on file, and it's just a recipe for errors and rash decisions. And it's obviously best to avoid all that. So it's really important to contact counsel and start planning and preparing for the case as early as possible. Next, there is the contingency planning, and this is important because Chapter 11, or bankruptcy in general, but Chapter 11 should really be a last resort. It shouldn't be the first choice. Certainly, there should always be some consideration and pursuit of other options concurrently while preparing for a Chapter 11 filing, and those other options could include, for example, some kind of out-of-court restructuring, settlements with major creditors that up until that point may have been pushing the company towards bankruptcy, obtaining forbearance agreements or other extensions of foreclosure proceedings from secured lenders. Or in California, you have the option to do an assignment for the benefit of creditors, what's referred to as an ABC, which is a state-sanctioned out-of-court process, which essentially is a liquidation of the company, similar to a Chapter 7 liquidation, but it's out of court. And obviously that option is only if the company is decided that it's time to liquidate the company. The reason it's important to consider alternatives to Chapter 11 is because if those other options are available or feasible, it really could save the company a lot of money in fees and costs and a lot of stress. All right, so that takes care of the pre-petition stage, and now we're going to the time when the company decided to file Chapter 11 and took the plunge, which takes us to the next major stage, which is the post-petition stage of the debtor's life. This obviously is the longest phase of this webinar, so we broke it down into 3 additional phases. You have the early phase, the middle phase, and the late phase. There is a lot to cover, so on the next 3 slides, we just provided a quick outline of the various topics and subtopics that we'll discuss regarding this period. But in the interest of time, we're going to kind of skip over these 3 introduction slides and move on to address the topics. But you do have on this slide here the early phase. This slide here is the middle phase, and kind of just a quick rundown of the subtopics. And then on this third phase, slide here, you have the late phase and some of the subtopics that we're going to get into. All right, so let's start in the early phase. Let's start with commencement of the case. So the case is commenced by filing a bankruptcy petition and paying the filing fee. In terms of where the case is filed, the company has a few options. They could file where the company is incorporated. So this means if a business does all its business in California, for example, but it's incorporated in Delaware, they have the option to file in Delaware. Second, they could file where the business has maintained its principal place of business or has its principal assets for at least 180 days. Or they have the option of filing if an affiliated company already has a bankruptcy case pending, the company could file its case where that affiliated case is already pending. Now, once the Chapter 11 is filed, the company becomes a debtor in possession, sometimes referred to, or almost always referred to as a DIP. The company remains a debtor in possession until or unless a plan is confirmed or a trustee is appointed or the case is converted to Chapter 7 or is dismissed. Now, it's referred to as a debtor in possession because the company, while in the debtor in possession mode, remains in possession and control of its business, of its operations, and of the company assets. And while a debtor in possession, the company has a fiduciary duty to the bankruptcy estate and to the creditors of the company. Now, it should be noted that the first few days of the case are extremely busy for both counsel and management. The representatives of the company, soon after the filing, usually get substantial inquiries from customers, suppliers, creditors, investors, employees, and sometimes even the media, depending on which company filed. Also, as we'll discuss, the early on in the case, the company representatives will have to meet with the U.S. trustee. They're also going to need to gather extensive information for the bankruptcy schedules, which we'll discuss. And they're also going to need to comply with various U.S. trustee requirements that we'll get into later. So the beginning stage, the early stage of this case, the first few days even, are fairly busy for both counsel and management. Now, once the case is filed, the debtor gets the benefit of the automatic stay. This is an extremely important protection that arises immediately upon filing the petition. It serves as an injunction that prohibits an extremely broad range of actions against the debtor and its property. The specific things that the stay enjoins is laid out, particularly in Section 362A of the Bankruptcy Code. It's designed to protect both debtors and creditors. For the debtor, it gives it a breathing spell from debt collection, litigation, and for creditors, it eliminates a race to seize assets. But it does not protect parties who are not in bankruptcy. So, for example, if an officer of the company is a co-defendant in litigation together with the company, then the litigation is stayed by the automatic stay as to the company that's in bankruptcy, but it still may proceed against the officer that is not in bankruptcy. There are multiple exceptions to the automatic stay, and those are listed in Section 362B as in boy of the Bankruptcy Code. And a creditor may also try to seek relief from the automatic stay at some point during the case. Now, any further detail on the automatic stay really is beyond the scope of this webinar. I could do a full webinar just on the automatic stay, and in fact, I did do a full webinar a few years ago. This is the next plug of a prior webinar. If you are interested in listening to that, there is a link to that webinar embedded in the PowerPoint that you will receive after this webinar is over. All right, let's now turn to the first filings and hearings in the case. So, whereas filing of the case does provide the debtor with various statutory protections such as the automatic stay and also gives the debtor certain powers that it didn't otherwise have pre-bankruptcy that also we'll get into a little bit later, it also does subject the debtor to various restrictions. And these are restrictions that are imposed to limit the debtor's unfettered discretion and ability to operate the business without court approval for certain actions. So, for example, as I indicated earlier, a debtor is prohibited from paying any pre-petition debts after it files bankruptcy, except as the court may approve. So, as a result, usually on the first day or the second day of the case, counsel for the company files several motions referred to as first day motions and appears at what's usually referred to as first day hearings on those motions. And the motions generally could be grouped into two categories. One, you have the operation-related motions, and two, you have more procedural or administrative type motions. Now, the first group, the operation-related motions, are designed to minimize any disruptions to the company's business operations and to ensure a smooth transition from being a non-debtor into a debtor. And we listed on this slide a couple examples of what I've termed operation-related motions. Some of those identified on the slide, as you can see, are motions seeking permission to pay pre-petition employee wages, motion seeking permission to pay pre-petition claims of critical vendors, as I mentioned earlier, motion for authority to maintain the company's current bank accounts and cash management system. And that's important because one of the USRC compliance requirements is to have the company close its pre-bankruptcy accounts and open new DIP accounts immediately upon filing. So this motion allows for at least some type of a transition period so you could smoothly transition into the new bank accounts. Also, a lot of times a motion for authority to use cash collateral is filed on the first day, which we'll discuss in more detail later. A motion to obtain the DIP financing, also which we'll discuss more in detail later. And another example is a motion to maintain various customer programs and benefits. The second category of first day motions, as I indicated, are more procedural and administrative in nature. And some examples, which we didn't identify here in the slide, but some examples include a motion to limit the number of parties that are required to get notice of certain motions or hearings. And this is important depending on the size of the case. If you have some cases have, a humongous creditor body and it's just not feasible to have to notify every single creditor, even if they're owed a de minimis amount of every single event that's going to happen in the case or every hearing. Another administrative type motion is a motion to jointly administer related bankruptcy cases, which generally allows all papers relating to the various related cases to be filed on one docket rather than filing the same thing on multiple dockets. As I think I indicated earlier, representatives of the debtor should be present at the hearings on the first day motions. And again, the hearings are usually set within the first few days after filing the case. Therefore, in addition to getting important and necessary relief, counsel usually uses this opportunity, or should use this opportunity, to introduce the case to the judge. And it's the first chance that counsel really has to gain or lose credibility with the court and just make the first impression on the court. Another thing that will need to be done early in the case is the filing of the company's bankruptcy schedules and statement of financial affairs, sometimes referred to as SOFA for short. Under the rules, these papers need to be filed within 14 days after the case is filed. And the schedules are a fairly comprehensive list of all the company's assets and liabilities with asset values and claim amounts identified. And the SOFA seeks a lot of information about the company's history of revenues and various transactions. And depending on the size and complexity of the case or complexity of the company, it could be a pretty large project that takes up a lot of management's time and could even overburden the company's staff depending on the size of their staff. So therefore, this is another thing that it's important to get started on as soon as possible, preferably before the bankruptcy case is even filed. And if appropriate, counsel could also include as one of its first day motions a request for an extension of time to file these schedules. All right, this next slide deals with insider compensation. An insider is a term defined in the bankruptcy code and generally includes controlling shareholders, officers, directors, and other parties in control of the company. An insider may not be paid their regular compensation without first submitting a notice of insider compensation. It's a form that's served on creditors and is subject to objection and a hearing. Insiders should be informed of this requirement before filing the case, and if they want to get paid, this notice is the notice that should be submitted as soon as possible after the filing. And it's obviously not good for client relations if, for example, the CEO of a company is not informed of this requirement until much later, and then is justifiably very upset that he or she cannot get paid their usual salary without going through this process and potentially having the compensation objected to. Another task that should be accomplished fairly early in the case is employment of the debtor's professionals. A Chapter 11 debtor is required to get court approval to retain any professional. This approval is obtained through filing an employment application, which is subject to notice to creditors and opportunity for hearing if someone objects. This applies to all professionals. It applies to bankruptcy counsel. It applies to the debtor's accountants, real estate brokers, and other professionals that would be rendering services to the company post-bankruptcy. The Bankruptcy Code requires that the professional be disinterested, and essentially what that means is that the professional is not permitted to hold any pre-petition claim against the company. There is an exception to this disinterested requirement, but as attorneys draft the Bankruptcy Code, this exception only applies to attorneys and only to attorneys that represented the debtor pre-petition in connection with a limited matter, such as a state court litigation. That attorney could be hired to continue representing the debtor in connection with that matter without satisfying the disinterested requirement. And again, it only applies to attorneys and no other professional. The employment application should be filed sooner rather than later, as an attorney cannot get paid, or any professional cannot get paid for services unless its employment is approved by the court. Lastly, in addition to getting approval for its actual employment, a professional will also need to get separate approval to be paid its compensation. This is done through the filing of fee applications, which also are subject to notice and hearing. Fee applications may only be filed once every 120 days. There are ways for professionals to get paid more frequently than every 4 months, but that is slightly beyond the scope of this webinar. Next things to consider for the early phase of the post-petition period is United States trustee compliance issues. So early in the case, the debtor will need to comply with various U.S. trustee requirements. Those requirements include the submission of a 7-day package. This is a package that the company needs to put together and send to the U.S. trustee within the first 7 days of filing the bankruptcy case, and hence the name 7-day package. The information submitted with this package relates to real estate owned or leased by the company, tax returns, bank account information, evidence of current insurance, and other operations related material. The second U.S. trustee compliance issue is that the debtor will need to attend an initial debtor interview. This is a meeting between just the U.S. trustee, the principal of the company, and the company's controller, or maybe even the company's financial advisor, and bankruptcy counsel. It's a fairly brief meeting. It just goes over company background, the debtor's restructuring goals, and also they go over these various U.S. trustee compliance issues, which leads to the third U.S. trustee compliance issue is the preparation and filing of monthly operating reports, as well as payment to the U.S. trustee of its quarterly fees. The monthly operating reports identify receipts and disbursements on a monthly basis, and the amount of the quarterly fee that's due and paid to the U.S. trustee on a quarterly basis is based on the total disbursements over that particular quarter. There has been in more recent years a substantial increase in the amount of the quarterly fees. We inserted the current U.S. trustee fee table in this slide, and as you can see, as you get to the $1 million or more quarterly disbursements, which is not that much, when you get to that box in this table, the fee could jump up pretty significantly. Finally, within about a month or so into the case, the debtor will need to appear at what's called the Section 341A meeting of creditors. This is an examination conducted by the United States trustee where the debtor testifies under penalty of perjury or the principal of the debtor. Examination relates to assets, liabilities, the bankruptcy schedules, which presumably would have been on file by then, the organization process, and status of operations. This examination, unlike the initial debtor interview, is open to all creditors, and any creditor has the right to appear and ask questions of their own. We spoke earlier about the creditors committee and identifying the key parties. And again, that's a committee that the U.S. trustee appoints in the case. And the committee is usually formed pretty early, at an early stage of the post-petition period. The formation process starts with the U.S. trustee soliciting creditors, usually the creditors that are identified on the top 20 general unsecured creditor list, and they solicit them to see if they want to join the committee. If there is interest, then the committee is formed. And again, it usually has between 3 to 7 unsecured creditors. Now, the committee, because the committee is supposed to represent the interests of the entire unsecured creditor body, the U.S. trustee usually likes to get general unsecured creditors of different types on the committee. So, for example, like to have some trade vendors, maybe some landlords, professionals that are owed money pre-petition. So just to make sure that the various interests of the different types of unsecured creditors are represented, so it likes to have a kind of a cross-section of all the unsecured creditor body on the committee. The committee is an important contingency in the case and could help the debtor through the case, especially if their interests are aligned against a particular adversary. The committee's general role is to consult with the debtor on administration of the case, investigate the conduct of the debtor and operation of the business, and negotiates with the debtor regarding treatment of general unsecured creditors under the plan, and often participates in formation and preparation of the Chapter 11 plan. The committee does have standing to appear and be heard in all matters in the case, and the court usually accords substantial weight to the committee's views. The committee also is permitted to retain its own professionals, which would be paid by the estate, by the debtor. Employment and compensation of those professionals also have to be approved by the court in the same manner as the debtor's professionals. In this regard, while the committee could be a useful ally to the debtor and help in getting through the case, it certainly adds another layer of fees and costs that the company will need to bear. Okay, that ends my portion of this webinar. I am now going to turn it over to Claire to finish up the remainder of the material.
Thank you, Asa. Okay, for the last part of the early phase of the post-petition stage of a Chapter 11, we're going to discuss how the company funds operations while in bankruptcy. Simply put, the debtor needs cash to operate, and the two usual sources of funding are 1, cash collateral, and 2, new credit/financing, which is also referred to as DIP financing. Cash collateral. Cash that is subject to a lender's security interest is referred to as cash collateral. The relevant code provision is 11 U.S.C. 363A. In order to use cash collateral post-bankruptcy, a debtor must obtain the agreement of the secured party, i.e. their consent, or court authorization. If the creditor does not consent to the use of its cash collateral, then the debtor must provide something called adequate protection. And adequate protection is designed to protect the lender's interest in its collateral. Now, adequate protection comes in many forms, including periodic payments to the lender, granting replacement liens on new collateral, and can even come in the form of an equity cushion or ongoing operations, because the company is continuing to operate and maintain its value. The debtor could also enter into a stipulation with the lender for use of its cash collateral. The stipulation, however, would require court approval, given that the stipulation may affect other parties, and given that lenders often try to extract additional concessions as part of their consent to use of cash collateral, which could include, for example, waivers of rights to challenge the validity and priority of their lien, or even waivers of rights to surcharge their collateral. DIP financing. Sometimes cash collateral alone is insufficient to operate the debtor's business, and the debtor may require a line of credit or other post-petition financing. The relevant code provision for this is 11 U.S.C. 364. Section 364 permits a debtor to borrow funds and offers protections and priorities to induce lenders to make these loans. Such inducements are offered because without them, lenders might be unwilling to lend. The inducements generally consist of a steadily increasing series of liens and priorities. A lender can get ordinary administrative priority, super priority, a lien on unencumbered assets, and if a debtor cannot get any of these types of loans, a lien on assets equal to the existing lien, or even something called a priming lien, which means that it's senior to existing liens. Now, moving on to the middle phase of the debtor's post-petition Chapter 11 life. As previously stated, activity in the case usually slows down after the first few weeks to a month. During this time, business operations tend to normalize and the debtor conducts business as usual, with minor exceptions as there's going to be certain obligations that are imposed by the bankruptcy code, less confidentiality, and more public scrutiny than pre-petition. The middle of the case generally provides the debtor an opportunity to evaluate its business plan and future financial outlook, options for exiting the case and what it may need to exit, such as additional financing. The debtor may also consider any litigation it may need to commence and may consider any other legal strategies. This period also includes evaluating ways to cut expenses and restructure operations. For example, a business strategy for a retail business might include shutting down stores and reducing its store footprint, reducing its workforce, rejecting burdensome contracts, and even selling assets or unprofitable divisions. Next, we'll move on to setting a deadline for creditors to file claims in the case. Now, to be allowed to vote on a plan or get paid on a claim, a creditor's claim must either be 1, scheduled on the debtor's schedules and not scheduled as disputed, or 2, the creditor must file a proof of claim with the court. The debtor will need to know the full universe of claims asserted against the estate at some point during the case, and it would really be best to have that information before filing the plan, but it's not absolutely necessary if you have a fairly good idea of the claims out there. The court will fix a deadline for parties to file a proof of claim in the case. The court does so either on its own, sometimes at a Chapter 11 status conference, or upon motion of the debtor. Setting this bar deadline should be done as early as possible during the case, and usually a bar date is requested at some point in the early part of the middle of the case. Asset disposition. Asset disposition, meaning the sale of assets, generally also occurs during this phase of the case, but could also be done in connection with a Chapter 11 plan. The two provisions that we'd like to briefly point out are Sections 363B and C. Section 363B of the Bankruptcy Code authorizes the debtor to use, sell, or lease any property outside of the ordinary course of business, but only with court approval. Whereas Section 363C authorizes the debtor to use, sell, or lease its property within the ordinary course of its business and without authorization from the court. So by this phase of the case, the debtor may determine whether it should sell certain assets, unprofitable stores, burdensome divisions, or even sell substantially all of its assets. If you're looking for more detail on bankruptcy sales, which again could comprise an entire webinar on its own, you can go to ACE's webinar on bankruptcy sales, which link will be provided once this PowerPoint is distributed. Or you could go to ACE's article in LA Lawyer on bankruptcy sales, link to be provided as well. Another issue that often comes up in the middle phase is the assumption or rejection of executory contracts and unexpired leases. Now, an executory contract is not defined in the Bankruptcy Code. It's generally a contract in which performance remains due to some extent on both sides, and the applicable code provision here is 11 U.S.C. 365. An unexpired lease is more easily defined. It's basically any lease that's still in effect. So executory contracts and leases can be assumed and performed by the debtor. They can be assigned to a third party, or they can be rejected. And contracts and leases, other than for commercial real property, can be assumed or rejected at any time through confirmation of a plan. Leases of commercial property, however, are automatically rejected if they're not assumed within 120 days after the petition date, unless that date is extended, and it's important to note that there are some limitations to a court's authority to extend it. Assuming a contract means that the debtor binds itself and all other contracting parties to perform the contract fully in accordance with its original terms. In order to assume a contract or lease, the debtor must, quote, cure all defaults, including pre-petition defaults, post-petition defaults, and must provide adequate assurance that it could perform under the contract or lease in the future. Rejecting a contract means that the contracting parties are relieved of any further obligations to perform their contractual duties. A claim based on rejection of a contract or lease could be divided into three components: a claim for any amounts due pre-petition, which would be a general unsecured claim; a claim for any amounts due post-petition, which would be a higher priority administrative claim; and a claim for rejection damages, which is generally the amount that the non-debtor contracting party is losing as a result of rejection of the contract, subject to any mitigation, and this would be a general unsecured claim. Rejection damages for leases are capped under the code, and the applicable code section there is 11 U.S.C. 502b6. A final note on executory contracts and leases: the decision to assume and assign, or reject a lease or contract requires court approval, and courts do typically defer to the debtor's business judgment. Moving on to claims administration and objection. At the outset, as you may or may not be aware, a Chapter 11 plan must classify claims in particular classes and provide the treatment for each class. So it's helpful to know the full universe of claims, including the total number of claims, amount, and priority. Before formulating a plan, the debtor will need to review all the claims that were filed, as well as its own books and records, and will need to determine whether any claims are improper and should be objected to, and certain common objections are listed on the PowerPoint for your reference. A debtor may assert objections on a claim-by-claim basis. Other times, the objections fall into broad categories, and the debtor can file something called an omnibus objection. One example of this would be the debtor objecting to all claims that were filed late or filed after the claims deadline. In the end, the claims resolution process determines which claims are allowed for payment purposes and which are allowed for purposes of voting on the plan. As a final note, claims objections sometimes follow confirmation of a plan, and the plan may assign the task of objecting to a party other than the debtor. Towards the end of the middle phase, the debtor may conduct plan negotiations and plan formulation. As a general overview, a plan may provide for comprehensive changes in the financial and business structure of the debtor, and such changes may include a sale of assets, the cancellation or refinancing of debt, changes in interest rates, and generally dictates how all claims will be treated. A plan can provide that a creditor's claim will be paid back over a greater period of time or at a different interest rate than was contained in the original instrument, and can provide for the conversion of debt to equity. During this time, the debtor should negotiate with parties regarding its Chapter 11 plan, including the committee, if any was appointed, secured creditors, suppliers, landlords, and other parties. More detail regarding plan requirements and confirmation are going to be discussed later on in this presentation. Also interspersed during this time period may be other miscellaneous issues that arise. Examples could include relief from stay issues, exclusivity issues, and landlord contract disputes. With relief from stay, for example, a creditor may seek relief from the automatic stay to exercise its remedies under state law, continue state court litigation, or to liquidate the amount of its claim. With respect to exclusivity, a couple quick points. The exclusivity period refers to the period in which the debtor has the exclusive right to propose a plan. That exclusive period is for the first 120 days of a case, unless extended by the court. After the exclusive period expires, other parties, including the creditors committee and secured lenders, may propose a plan or a competing plan. Finally, as to landlord contract disputes, among the various issues that may arise, a landlord or contracting party may want the debtor to make a decision regarding assumption or rejection of a contract or lease earlier than the deadline fixed by the code, and may file a motion to compel an earlier decision, which is something that the debtor would then have to address or work out. The main takeaway here is that it's important to stay focused on reorganization despite any issues that may pop up during the case. And now we are at the later phase of the post-petition stage. During this time, the debtor may commence litigation and deal with other contested matters. Common litigation in Chapter 11 includes avoidance claims, i.e. preference actions, fraudulent transfer actions, and other strong-arm powers, and claim objections, but there may also be other litigation. At this point, we are now entering into discussions of the Chapter 11 plan, and a successful reorganization through such a plan is oftentimes the goal of a Chapter 11 case. The basic chronology in confirming a plan is set forth on the PowerPoint, some of which we did discuss earlier, and includes negotiating the plan with creditors or counsel, drafting the plan and disclosure statement, getting the court to approve the disclosure statement, soliciting votes for the plan after the disclosure statement is approved, counting votes, and requesting that the court confirm the plan. So briefly, what is a disclosure statement and a plan? A disclosure statement is a document that contains information concerning the assets, liabilities, and business affairs of the debtor sufficient to enable a creditor to make an informed judgment about the debtor's plan of reorganization. And the applicable code section here is 11 U.S.C. 1125. A disclosure statement must be approved by the court before a debtor may send the plan to creditors or otherwise solicit votes to accept its plan. And it's actually a violation of the bankruptcy code to solicit votes before the disclosure statement is approved and could result in denial of confirmation of the plan, so don't do it. A plan is filed together with a disclosure statement, but may not be circulated to creditors until after the court approves the disclosure statement. A plan could be a reorganization plan or a liquidation plan, and the bankruptcy code identifies what must be and what may not be in the plan. Basically, the plan must put each creditor in a particular class and identify how such class will be treated. The debtor has a lot of flexibility in determining this treatment. The classes generally include secured creditors, general unsecured creditors, and equity interests. Each secured creditor should be in its own class. General unsecured creditors will all be in a single class together unless the debtor has some sort of business justification to single out a particular unsecured creditor, and equity interests should all be in a single class together. Some creditors are not classified but are still treated under the plan. These include administrative claims, such as the claims of professionals employed in the case, and priority tax claims. The bankruptcy code already dictates how they must be treated, so there's not much flexibility there. Okay, solicitation and voting. After approval of a disclosure statement, the debtor or plan proponent solicits votes on the plan. Solicitation is done by mailing to all creditors and other parties copies of the plan, the disclosure statement, and various other solicitation materials. This could include a letter of recommendation from the committee to get general unsecured creditors to vote in favor of the plan. And this is something that we had done in a previous Chapter 11 that was successful. Voting is done on a class-by-class basis, and only creditors whose claims are impaired, meaning that their contractual rights will be modified or that they will be paid less than the full value of their claims under the plan, are allowed to vote on the plan by ballot, so long as the creditor holds what's called an allowed claim, meaning that the claim is not subject to objection. Claims that are not impaired are deemed to have accepted the plan and do not vote on the plan. And finally, in order for a class to be deemed to have accepted a plan, the plan must be accepted by a majority in number of creditors who vote and at least 2/3 in amount of debt of the voting creditor claims in that class, not counting insider votes. Plan confirmation general requirements. Broadly speaking, the Bankruptcy Code requires the court to make a number of specific findings to confirm a plan and make it binding on all parties, and those are set forth in sections 1129A and B. Plan confirmation is complicated and technical. You really should have competent bankruptcy counsel to represent the plan proponent or the debtor in order for the plan to be confirmed. There are also some specific requirements for confirming a plan. There must be a finding of feasibility, and unless every single creditor accepted the plan, it must also meet the best interest of creditors test. Feasibility has two aspects. One, that the debtor will have enough money to pay all claims designated to be paid on the effective date of the plan. That's usually the date that the order confirming the plan becomes final. And two, that the debtor is reasonably expected to have enough money to make all future payments contemplated under the plan over the period set forth in the plan. The best interest of creditors test, also referred to as the liquidation analysis. Under this test, the court determines that creditors are getting under the plan at least as much as they would receive if the debtor were liquidated under a Chapter 7 bankruptcy case. This is really only relevant as to creditors who voted against the plan. If all creditors accept the plan, then this requirement becomes moot. Another aspect of plan confirmation is the potential to cram down on creditors, where it would be nice to have all parties and all classes accept the plan. The court could still confirm a plan even if a class of claims rejects the plan. This is called a cram down because the plan is being essentially crammed down on the objecting classes. And the debtor must meet certain requirements to confirm a plan through a cram down, which requirements would include that the treatment provided for the objecting class must not discriminate unfairly and must be fair and equitable. So what does unfair discrimination mean? It means that a debtor may discriminate against the class, it just must not be unfair. For example, the bankruptcy code allows a plan to include something called an administrative convenience class, which is a class of general unsecured creditors underneath a certain amount, and the plan may provide for better treatment than for general unsecured creditors with greater amounts. This is not considered unfair discrimination. As to the fair and equitable test, what this means depends on whether the objecting class is a secured class, general unsecured creditor class, or equity class. A main feature of this test is the so-called absolute priority rule. That rule essentially is that no class that holds a claim or interest junior to another class is paid anything unless the senior class gets paid in full. If not, then the treatment of the senior objecting class should be deemed to be receiving fair and equitable treatment. The next step in the plan confirmation process is the hearing/trial, in which the court conducts a hearing or trial and determines whether or not to confirm the plan. As to the impact of confirmation, a confirmed plan becomes the law of the case. It's a substitute contract that governs the relationship between creditors and the debtor. Prior contracts or terms no longer apply, and the plan now dictates those terms. Okay, we're now entering the final stage of the life of a Chapter 11 debtor, the post-confirmation stage and the exit from Chapter 11. On the effective date of the plan, the debtor becomes something called the reorganized debtor, and generally is free from the strictures of the bankruptcy code as it was before it entered bankruptcy. The debtor may continue operations as usual or as otherwise set forth in the plan. Oftentimes, there are a number of important aspects that remain to be completed after confirmation, including consummating transactions provided for in the plan, resolving claims, and litigating adversary proceedings. The debtor is also required post-confirmation to report on the progress made in implementing the plan, which could include post-confirmation status hearings before the court. After the plan is consummated or substantially consummated, the debtor may file a motion for entry of a final decree and seek to close the case. You may be wondering after confirmation how the debtor actually implements the plan. Well, the plan needs to identify something called a dispersing agent, which is tasked with making the payments called for under the plan. The debtor is often designated as the dispersing agent, sometimes for free and sometimes for a small fee. A plan could also provide for the appointment of a plan trustee, plan agent, liquidating trustee, or similar party conferred with certain duties, such as selling assets, pursuing litigation/avoidance actions, or various other acts to collect assets or cash to fund payments under the plan. Now, we're going to end off this webinar with the most important part, at least to most attorneys, the payment of attorney's fees. As mentioned earlier, professionals employed in the case must file fee applications approving their fees and costs. And while the code allows interim fee applications to be filed once every 120 days, following confirmation, professionals must file a final fee app to get final approval of all fees and costs incurred, including those approved earlier on an interim basis. Most of the time, these fees are allowed, but you should be aware that depending on the case, the court may allow the fees, deny them, or even require disgorgement of fees paid on an interim basis.
Okay, thank you, Claire. That brings us to the end of the webinar. I recognize that we did run through the material fairly quickly because we wanted to keep it within the hour. I'm not sure we fully succeeded. We may have gone a little bit over an hour. And I know there's a lot of information, and we provided it in a very summary fashion. But if you have any questions, whether about anything raised in this webinar or any other bankruptcy or restructuring related matter, please feel free to reach out directly to either Claire or me offline, and we'd be more than happy to speak with you or answer any questions you may have. Thanks again, and we are now signing off.